Following the Supreme Court's judgment in the Michael Kabazi-Guruka versus the Attorney General, which declared the trial of civilians in the General Court-Martial and Constitutional and ordered an immediate halt to such proceedings, the government was advised to amend the UPDF Act to align military trials strictly with constitutional principles and transfer all pending cases to civilian courts. However, to date, civilians facing trial in military courts have neither been released nor transferred to civilian courts. Prison authorities claim they have not yet received official orders raising concerns over compliance with the ruling. Constitutional lawyers, however, argue that court orders take immediate effect regardless of whether those affected have been formally notified. They emphasize that continued detention without legal basis amounts to unlawful imprisonment.
It's important that they are served with particular documents. However, when a judgment is made, a judgment becomes effective the moment it's read. It doesn't matter whether you are aware of it or not.
Musisi states that the Attorney General, as the government's chief legal advisor and a party to the Michael Kabazi-Guruka versus the Attorney General case, is mandated to formally notify prison authorities of the Supreme Court ruling. He emphasizes that it is the Attorney General's responsibility to ensure compliance with the court's directive facilitating the immediate release or transfer of civilians previously tried in military court.
Internal mechanisms of how the Attorney General communicates the prison, that is internal. It's irrelevant. In fact, even if no one communicates the prison, they are taken to be aware because the Attorney General, their legal representative, was in court. Attorney General is the chief government legal advisor.
He says the Attorney General and the Director of Public Prosecutions must expedite the process of either transferring cases to civilian courts or filing fresh charges against individuals they intend to continue prosecuting. Musisi notes that all detainees who were scheduled to appear before the General Court-Martial today are now being held illegally as their remand period has expired.
They have to go to the magistrate courts, the DPP has to sanction fresh charges, and the person has to take plea afresh. All the people, they have to take plea afresh because the DPP here cannot continue with the other charges which they did not institute.
Referring to the President's comments on the Supreme Court ruling, Musisi asserts that any attempt to amend the UPDF Act to reverse the court's judgment would be unconstitutional. He cites Article 92 of the Constitution, which prohibits Parliament from enacting laws that alter a court's decision in relation to the parties involved, and I quote, "Parliament shall not pass any law to alter the decision or judgment of any court as between the parties to the decision or judgment." Musisi emphasizes that while the government can amend the law based on recommendations, it cannot legislate to overturn the Supreme Court ruling.
Adam Mayambala, reporter, has been on this story, and we want to understand from him. Adam, where is the confusion coming from? Why is there delay in the implementation of the Supreme Court judgment?
The issue of implementation revolves around the extensive paperwork that needs to be done by the DPP, especially if we speak about instituting new charges, because I don't see the gates of prison opening so wide for every prisoner that is under trial in the military court.